I'd like to welcome everybody to this morning of the Michael Green's list, CPD. My name is Paul Santamaria and I'm a member of Michael's list, for good or bad. It was a funny little coincidence of events in the days after Cup Day. A colleague of mine with whom I had shared chambers in 1984, 1985 for a year or two, knocked on my door, I think it was the Wednesday after Cup Day, and proceeded to return to me my copy of Crossley and Vane's Personal Property 3rd edition, which he had borrowed. I was completely unaware that the book was missing from my library for about 25 years or so. But I glanced through it. I saw it was mine because of the absurdly pretentious signature on the front page. And I reintroduced myself to old friends such as Milroy and Lord and Nemo dat non quod habet, which of course used to strangle us when we were doing university exams. And those rotten problems that were set about finding an old cup on a disused farm, etc. So I thought, there you go, personal property. It's been a while. And in the same week I spoke to my bank manager, and I tend to speak to him quite a lot because I'm always asking him for permission to do one thing or another. And if I'm to buy a new mobile phone or something like that, I would always ring the bank manager. On this occasion I rang him to see if it was okay if I bought a new car, and he was a bit cautious about that, but he gave me his permission. And I said to him that I'd have to borrow the lot as usual, and he said, well, you've got an ABN number, are you going to lease it or put it on a chattel mortgage? And I affected to know the difference in the conversation but scrambled to get off the phone so I could look it up. The word chattel is a word that will only probably be found now in books like Crossley and Vane's, or if you read St Paul's Gospel from time to time. But I concluded that I definitely needed a refresher in the law of personal property. And the trifecta of events was completed when I received a call from Brett Bowker, Brett being one of Michael Green's assistant clerks. And Brett wasn't ringing to tell me that I had won something in the Michael Green Cup sweep. Brett could have rung me before the race to tell me that I wasn't going to win anything in the Cup sweep. I should say that my secretary harbours suspicions about the Michael Green football tipping competition as well, and I have to stop her from calling the gaming squad from time to time during the season. No, Brett was ringing to tell me that I'd volunteered to chair this morning's CPD session on personal property securities, which is to be delivered by Adrian Muller. All I know about this particular piece of legislation is that it's something like the torrent system for cars, boats and horses, perhaps. But even if I hadn't been asked to chair this morning's session, I would have been here to listen to Adrian's paper because he traverses a topic which is, I think, under-considered by lawyers, but which is very important in the commercial lawyer's body of knowledge. The Personal Property Security Act might mean that I don't need ever again to open my copy of Crossley and Vane's, but we'll see. Now, let me tell you about Adrian. Before coming to the bar, Adrian was a senior associate in the dispute resolution group at Baker & McKenzie Lawyers, and he's got a lot of experience in advising and acting for both Australian and international clients in a range of commercial and corporations matters, including shareholder claims, directors' duties, corporate compliance, schemes of arrangement and insolvency matters. And I think he's developed in his practice at the bar good experience in alternative dispute resolution processes, including negotiations, mediations and arbitrations. but he's also advised in a range of other areas, including trade practices, professional negligence, torts, media law and property law disputes. So he's got a very solid general practice in commercial law. I was interested to read that Adrian also has some special experience in compliance issues, including the United States Foreign Corrupt Practices Act, related issues, bribery and corruption risks. And I thought that that experience might be made useful next year when Michael Green runs the Melbourne Cup sweep, because it will certainly assuage the concerns of my secretary when it comes to the picking of horses. So, Adrian, I'd like to introduce you to the group, and I should add also that, just to adopt the racing metaphor, we've had one scratching in that Adrian's fellow presenter, David Fabretto, was unfortunately required to go to Sydney last night, and he offers his apologies because he's not able to join us this morning. Might also add that although the materials are normally handed out as part of a paper, what Adrian is going to do is to provide the, there's a PowerPoint presentation, I was about to say slideshow, that he will speak to, and that will be distributed, I think, electronically during the course of the next day or so. So would you welcome Adrian Muller?
Thank you, Paul. One always sounds much more confident when you hear someone read out your CV than one usually feels day to day in practice. So I hope you'll bear with me with that. And I also apologise if you've come not to hear me speak, but to hear David speak. Unfortunately, he's, as Paul said, not able to be here. What I want to do today is, by no means detail, but I hope that at least it's comprehensive in that it, perhaps to keep the racing metaphor going, covers the field in terms of touching on the key points that you need to know and understand about the reform to personal property securities, which will come into play if there's no other amendments to the Act in February of next year. I'd like to do that by giving you a broad summary of what the Act is and what it does, and then to look at some of the key terms and some of the key definitions so that you begin to get the language that you need to understand and delve into the Act yourself. And then briefly I'd like to touch on three particular areas. It's what's called purchase money security interests, the extinguishment provisions and the register, which is a critical and important part of the reforms that the Act brings in. As I said, the Personal Property Security Act is Commonwealth legislation. It covers both the Commonwealth and the states by referral power from the states up to the Commonwealth. And so what it does is it replaces most existing Commonwealth, state and territory laws and registers for personal property securities, which covers things like company charges, bills of sale, and then some more exotic things like ship mortgages, helicopters, aircraft, crops and stocks, all that sort of thing. Stocks both in terms of animals, and then there's a carve out so it doesn't include stocks as in terms of trading of securities. And what it does is introduces major substantive change to the current law, and it's important to people who deal with personal securities all the time, be that in terms of their business, that they lend and take security over collateral when they do, for us as lawyers who need to advise, who need to draw contracts and amend contracts. And it's important to people who are just in general trade and commerce, because it to a large extent rewrites the law and the way that we operate in terms of retention of title clauses, or remolpa clauses, as many of you would know them as. And just to note too that when I send the notes out, they really are an overview, so they don't cover all of the aspects of each of the areas they touch on, and they certainly don't cover all of the operative provisions of the Act. So it's very much designed as an overview, and I trust that you'll read it like that rather than looking at it as something that you can go to take the substantive law from. As I said, the Act will come into effect on the 1st of February next year. It's already been delayed twice or 3 times. It was to come into effect in March this year, then that was delayed until October this year. And it's been further delayed until 1 February next year, where it will come into effect unless there's amendments to the Act. So we're now in the end game, if you like, of the Act coming into play. And so that puts us into the start of the transition provisions between what will happen with existing securities under existing state and federal laws as we move into a regime that is designed to replace all of the existing laws as to personal property security. At the moment, there are a number of different registers around the country. There's something in the order of north of 60 or 70. Most of those will be closed, and the securities that are registered on those registers will be transferred across onto the new register that operates under the Personal Property Security Act. For example, under the Corporations Act, ASIC keeps a register of charges that are recorded against companies when a company gives a fixed and floating charge, for example, over its assets. That register will cease, and the securities, rather than being registered under the Corporations Act, will be registered under the Personal Property Security Act. Similar thing will happen for motor vehicles that at the moment under state legislation there's a registry that's kept of motor vehicle VIN numbers, vehicle identification numbers. That too will cease, and there'll be a transfer across to the new regime under the new Act. That brings up a couple of practice points for people who are dealing with these things. The first is you might have clients ask you, my securities which are registered under a particular state act or a particular federal act at the moment, will that transfer across to the new PPSA? The answer is you'll have to look in terms of each specific register and see whether it transfers across. The second thing is because the new register under the PPSA has a heavy reliance on the accuracy of the information that's contained in the register, you or your clients will need to check to ensure that when it's been transferred across, that it's been transferred across accurately, and particularly in terms of things like vehicle identification numbers. If the digits are not correct, then that can affect the efficacy of the security. Another aspect of the transition provisions is that it doesn't, aside from items that are already registered on a register that is being transferred across to the PPSA, it doesn't affect existing securities. And so there is a 2-year window in which clients have to transfer their existing securities across into the new regime, and if they don't do that, then at the end of that 2-year transfer or transition period, then their interest will be ineffective at the end of that period. So it's important that a review is done of all of the securities that people have to make sure that they have been transferred across, or if they haven't been transferred across, that they're picked up in some way and transferred across onto the new register. Let me talk to you about a broad summary of what the PPSA is. And we start with the concept of a security interest. And that takes what we call a broad functional approach with a focus on the substance of the security rather than the form of it. So rather than looking now to see whether it falls within a particular type of transaction, if it falls within the definitions of being personal property, which is very broad and we'll come to that later, then it's covered by the it's covered by this Act. So if in substance it's a piece of personal property that forms collateral for some form of loan or advancement, then it comes within the regime of the PPSA. The second thing that's important to note is that title's not relevant except in relation to purchase money security interests. So the Latin that Paul was quoting to you before, by and large, passes by. There are provisions, of course, for people with better title to register and obtain their priorities, but you don't need to have title to a piece of property, call it collateral, in order to give that as security to someone else in return for them loaning you money or whatever it is. Another aspect of the regime is that on insolvency, unperfected security interests are not effective and the collateral returns to the grantor unencumbered. So we'll get to what the perfection process is later on, but what you start to see as this Act unfolds is that there is a series of requirements that people need to follow in order for them to gain the benefits of protection under the Act, and if they don't do that, then they stand at risk of not having any of the protections that we would have thought, or we do have under current general law and various statutory regimes. And so again, as Paul said, in many ways it's similar to what the Torrens title does for land, is that it elevates the registration process, in this case the PPS register, to a much higher level than what we currently have in terms of legal and equitable interests in personal property. Another thing that it does is it gives consistent rules to determine the priority of security interests, and that, broadly speaking, is subject to some exceptions, and the purchase money security interest is a major one. It's based on first in time for perfection, and importantly extends to future advances as well. So again, we'll go to the detail of that in a little bit, but if you register first, then you get the best protection. As a consequence of that, by and large, notice of a prior unperfected security interest doesn't affect priority outcomes. So a lot of the law that we all learnt about whether you take with notice or you take without notice, whether you have a legal interest that you take with notice of a prior equitable interest, the Act does away with that. So what you're left with is, if you perfect your security by using the registration process and following the requirements of the Act, then you take priority, even if at the time that you do that, you know that someone else has what the Act calls an unperfected security interest, or perhaps in the old language what we'd start to refer to as some sort of equitable interest or equitable security. And that's a very important change, because it's change both to the function of the way that we operate, but more importantly, it's a change to our thinking about how we go about advising our clients on where they stand in terms of protection and where they stand in terms of the effectiveness of their security. It doesn't, though, affect the form that people need to use in terms of negotiating their agreements. As long as it satisfies some very basic requirements, then parties are generally free to negotiate the terms of their security agreement without satisfying any prescriptive form. There is some more prescription in terms of the registration process, but in terms of the actual security agreement, there's very little guidance given in the Act about what needs to be included in that, save for touching on some things in terms of having requirements there for describing the collateral so that you can enforce against third parties and the like. The Act also does away with the idea of fixed and floating charges, and so it leaves no real ongoing relevance for concepts such as crystallisation. And it does that because the Act moves to a situation where once you have a security interest that's granted and collateral is given, then what happens at that point is the security interest attaches to the collateral. And so it's at that point that you have the creation of the security agreement and the security interest. And under the Act, that can also apply to future transactions, which removes the need to have the floating element of the charge. So it's possible now to take a security interest over all of the assets, both present and future, of a company, save for, and then there might be exclusions of various things that come out. But that attaches at that point in time, not at some future point in time upon an event of default. And that's, I've just picked up there what I've just said. And going back to our Latin that I won't even attempt to mangle, the Act removes this idea that you can't give what you don't possess. So under the PPSA, a grantor who does not hold legal equitable title to personal property can still give a security interest in it. Usually, just by having possession of it will be sufficient to enable them to do that. And so again, that's a fundamental shift to some of the things that we have been taught all the way through our legal training. The protection that it affords people who have given possession to someone else is that they are obviously in a position also to take a security interest over that if they've given it to someone without, whilst retaining title. And so, again, it's important if someone's in that situation that they go through the proper processes to secure their legal position and secure their right to a priority by being first in time. So that's a very broad overview of how the Act is designed to operate. There's a lot more detail, obviously, in terms of the rationale behind it, in terms of what other countries have implemented it. It's been used for quite some time now in the USA, in Canada and in New Zealand. And there are various policy reasons for it being brought into Australian law. I won't go into them. There are some good texts around if you want to read them to get a better understanding of what the purpose of the Act is and what some of the broad concepts are. But let me now sort of take you to the idea about the way the Act operates. And the way the Act operates is designed to do this, is that when you have a security agreement between what's called a secured party, who's the person loaning the money, and a grantor, who's the person who is offering up collateral is security for the loan, then at that point you have a security agreement and you have a security interest by the secured person in the personal property. Once you have that, then you have a legal right to the collateral, and you can, as between the secured party and the grantor, deal with that security, take control of the security if there's a breach of the loan agreement, take it in, sell it, do what you would normally do. But that's only the first step of the story. The second step is that in order to get the protection of the Act, you need to do what's called perfect the security interest. And that's done in one of three ways. It's to take actual possession of the collateral so that then you hold it and you don't need to do anything more than that. The second is in various circumstances about deposits in approved deposit-taking institutions is to take control of the collateral. And the third way is by using the registration process under the register. And the register is kept by the Insolvency Trustee of Australia. It's designed to be an online, accessible 24-hour-a-day registry that you can go in and search to find out whether a piece of personal property has been given as security for a loan. And if you go through that process, then you get a registration date for the security interest, and that registration date gives you priority against people who come later than you in time. And so that's called perfecting. So if you've got a perfected security interest, then you defeat perfected security interests that come after you. So someone might take a second mortgage over a chattel, and they would come, as we would expect, lower ranking. It will also take precedence over an unperfected security interest that is earlier in time, even if at the time that the security interest is perfected, you know about the earlier unperfected interest. So that's, yes?
I'm not sure if you're going to come to this, but is there, I wouldn't say fraud, but if there's a scheme to try and defeat one particular advancer of funds by having two interests granted very close in time, with the subsequent interest security party being registering first, is there protection against that?
The question is there some sort of protection against fraud by people being involved in transactions very close to each other? That exception, what I just said about the priorities, doesn't apply if the party taking the later perfected security interest was a party to the earlier transaction. So there's a carve-out there, and otherwise the Act doesn't purport to carve out fraud and give an exemption for fraud in a similar way to it's still, even though under Torren's title, if you have registration, then you can hold that up against the world and say, I've got the best position. That registration can be defeated by fraud, by an allegation of fraud that's proven, as the similar effect is here. So I think I've covered this. A person who holds security interest is referred to as a secured party, and a person who gives or gave the security interest is referred to as the grantor. And there are two types of security interests, broadly speaking: in substance and deemed security interests. Set out there for you a list of transactions that provide for security interests, and you'll see there most of the things that you would expect. But having a transaction is not the only thing that you need in order to give rights to a security interest. You also need to, the transaction needs to provide for an interest in the personal property, so there needs to be some form of security that's offered up, and it needs to be in substance a security for payment or performance of an obligation. Under the Act, interest is defined to include a right in personal property, and there's some discussion around whether that broadens the effect of the general law position that we're dealing just with property rights, and whether there now can be some scope for inclusion of contractual rights. That's at this stage an academic discussion because the Act hasn't come into play yet, and no doubt at some point will be tested in the courts, but it's something to be mindful of at the moment, that the wording of the Act may allow for a broader definition than what we had previously expected. Talking about in substance, secure payment is in terms of the economic or the commercial substance of the transaction rather than its legal substance. And as I've said before, if it does that, then it gives rise to a security interest regardless of whether the grantor is the owner of the collateral. The second type of security interest is what's called a deemed security interest, and they are the first three bullet points that are set out there. The most important one of those, I should say that Paul suggested that we'd never need to use the word chattel again. That's not quite right, because in our Northern American friends have a concept of a chattel paper, which I have to confess I don't fully understand. And that language has been imported into our Act to give consistency with some of the other acts around the world. So if you're going to deal with North American people, Paul, you might still need to use that word. The most important deemed security interest is the interest of a lessor or a bailor under a PPS lease, which is a lease that is for a term of 2 years or more, or a term of 1 year plus 1 year that has the effect of being 2 years or more. And what that means is that that creates a deemed security interest that can then be used as collateral and can be used as security for other purposes. And there's no need that for a deemed security interest that the transaction in substance secures payment or performance of an obligation. So it's simply the fact that it's there that can give rise to it. The consequence of that is that the enforcement rules don't apply, but the priority and extinguishment rules still do. So again, we'll pick up some of that a bit later on. Start to see how the Act operates when you look at guarantees, because a guarantee operates to secure payment or performance of an obligation, but in and of itself, it doesn't offer up any form of personal property as collateral. So a guarantee by itself doesn't fall within the PPSA regime and can't give rise to being a security interest. The situation changes, of course, if the guarantor gives some sort of security interest over his or her personal property. So if they give a charge, or if they offer up security over a house or a car or a boat or a helicopter, whatever, then that is enough to bring it back within the regime. But in and of itself, it doesn't. And that highlights the importance to look at the actual transaction and see what the substance of it is and what actually is being offered, what's being given and taken, to make sure that it falls within the ambit of the Act. The next critical definition is that of, well, what is personal property? And it's very broad. It basically covers any property that's not land or is not a right, entitlement or authority granted under statute, if that statute declares that it's not within the PPSA. And then the PPSA itself has some carve-outs, and I've listed them there for you to look at later on in terms of things that don't fall within the ambit of it. Perhaps of most interest to us is that solicitors' liens don't fall within the ambit of the PPSA, so you can't use them to secure something else. And then we come back to this idea of what is a security agreement, which is the central point of how the Act operates. A security agreement is very broadly defined in the Act. It's something that will be effective according to its terms, subject to other restrictions of the PPSA in terms of what you can and can't contract out of in the enforcement provisions. And obviously it has to create the security interest. So the security agreement has to in some way create the security interest that then becomes what's registered or perfected under the Act. If it's just as between this secured party and the grantor, then it doesn't need to be in writing. But to be effective against third parties, then it does, and it needs to identify the collateral with sufficient precision so that it can be identified by others. Another thing about the security agreement to be cautious of is that in certain circumstances, third parties can have access to the security agreement. Pardon me. And so one of the things that you might want to look at as you're drafting documents is whether there are commercially sensitive terms that need to be taken out of the security agreement and put in into another document, a secondary document that won't need to be disclosed to third parties. And then the final thing that I wanted to talk to before we break is the idea of attachment. Under Section 19 of the Act, a security interest attaches to collateral when the grantor, that's the person who has the collateral, has rights in the collateral or the power to transfer rights to the secured party, and either value is given or the grantor does an act by which the security interest arises. And under the PPSA, again, this is a change that's significant from the existing law, is that past consideration will be sufficient to support attachment. All right, we might take a short break there because Paul's given me a nice little note, and then we'll come back to deal with issues like third parties and enforcements. Thank you.